a grievance. Mr. Goth has, my understanding, filed a grievance against Mr. Slough and Mr. Thompson.
Never filed one on Mr. Shaw.
Mr. Thompson, I'm sorry, Mr. Goth indicated he's filed a grievance against Mr. Ziegler. So in the middle of a murder trial and prepping, I have to deal with grievances that have strict time constraints and requirements and turning over documents and other things that come with the own separate proceedings that I believe are frivolous, but I have to deal with those. And I've just reached a point where I've had a breakdown with Mr. Galt. And then I can't do my duty. My loyalty to Mr. Galt is just diminishing because of his actions, his conducts. It's not something that I've done or I've not done for him. You know, I've got kites from Mr. Galt that he indicates he doesn't have discovery. He's got 2 sets of discoveries, 10,000 pages or so of copies that have been made and provided to him. So when he says he doesn't have those, they're untrue. And I just can't do these things and then get into a position where I have to deal with grievances and malpractice suits when those are again frivolous, that he's claiming that he's filed and he's done those things. So I've reached a point where there's a breakdown. I will admit to the court, the only thing that Mr. God does not have is the search warrant body cams, because I got them this morning from Mr. Ziegler. They're in my pocket. And again, certainly my intent is to download them to my office drive, so I have a copy. There's a laptop at the jail, and then Mr. God will have a copy to watch those there. So that's the only thing that he doesn't have, but he doesn't have those because we didn't have them until this morning when Mr. Ziegler handed them to me in court. Outside of that, I've had numerous emails with Mr. Ziegler, numerous phone calls. We've talked about a lot of other issues, litigating issues. At one point, Mr. Galt wanted me to set up some interview with the FBI. And in fact, made threats because I was not doing that, made threats towards me for not setting up the interview. And again, I indicated to Mr. Galt, I need to know what you're going to tell the FBI because you have certain rights. If you're going to incriminate yourself, I have to advise you and warn you of those rights. He wouldn't tell me. We did set up the interview. The interview was recorded. And again, Mr. Galt, that interview never went anywhere because Mr. Galt got angry and upset because it was being recorded. The FBI agent did Mirandize Mr. Galt, and that's not how Mr. Galt wanted to operate. So all of the things that Mr. Galt has done has, at least for me as an attorney at this point, led to a breakdown where I can't communicate with him. I can't represent his interest, and I refuse to go forward with this case and assist Mr. Galt any further because of what he's done with his verbal abuse, his threats, his derogatory attitude towards me, and I'm just refusing to put up with it.
Welcome back, everyone. Today we're diving deep into a courtroom showdown that's packed with drama, tension, and explosive breakdowns. Right from the start, you can feel the pressure building as the attorney describes an absolute collapse in the attorney-client relationship. Multiple grievances, threats, and hundreds of pages of discovery have pushed this case to the breaking point. The lawyer is at his wit's end, claiming he can't effectively represent his client due to verbal abuse and uncooperative behavior. Stick around, because what happens next raises serious questions about legal ethics, client rights, and courtroom strategy. You're not going to want to miss a second of this.
To withdraw. Mr. Galt would grieve him, and we can play this game for however long as Mr. Galt wants to play it or however long as the court wants to entertain it. But at the end of the day, we're going to have a trial on this case. There's no likelihood of any sort of plea resolution. We have a trial set in May. I would prefer to have that trial as opposed to appoint a new attorney, kick the case out 6 months, and then come back here in 6 months on probably similar issues where that attorney is not going to want to file frivolous motions. And Mr. Galt wants that attorney to file. So for those reasons, Your Honor, I don't think the court has to permit Mr. Gurmurthy to withdraw. I'm certainly sympathetic to Mr. Gurmurthy's position here today. I think he had to do what he had to do. He had to file this motion. He had to make his conflicts known to the court. I certainly wouldn't want to be in his position today, Your Honor, but from my perspective, I have a duty to the victims to bring this case to a trial and to a resolution as quickly as possible, and I would oppose any further delays.
Mr. Galt, anything else that you want?
Your Honor, file motions on are legitimate things. The fact that I never even got a copy of the motions that he filed is legitimate. You know, Your Honor, you're the one that told him This is unacceptable. You didn't show up to court. This is unacceptable. You did not file your motions on time. That was 14 months. Mr. Seeger killed 5 months before he was willing to withdraw because of the conflict issue. I didn't grieve Mr. Seeger for another 6 months after that. So it's not why, the grievance is not why it got handed over to Mr. Thompson. The grievance didn't come for months, 6 months after Mr. Guramuthi was assigned the case. Okay, I mean, I got a search warrant right here that was never signed by a prosecuting official, by a non-attorney magistrate. You know, Mr. Guramuthi fails to be willing to file a motion on these things. Your Honor, you said in court last time we were here that you're not going to have this come back on an appeal. Your own words, Your Honor. So these things are things that are going to make this come back on appeal. Mr. Guramuthi just got a copy of the body cam footage of the search today. 18 months, Your Honor. And he just got it today. I've been requesting it the whole time. I've been requesting officer activity logs the whole time pertaining to the deactivation of body cam footage. I've researched case laws. I mean, all these things are legitimate motions that should be filed, Your Honor, and you, Your Honor, get to rule on them whether they're frivolous or not. That is your job. These are legitimate things that counsel should be filing motions on. As a defense counsel, he works for the state. You know he works for the state. He don't work for me. You know, he's told me several times, I got funding for this, I got funding for that, I got funding for the transcript. I contacted Nicole Hagstrom, the transcriber. She said, I contacted Mr. Guramuthi. He said he'd do what he has to do on his end. We'll get you them transcripts. Nothing. I got a paper right here signed from Mr. Paul Stout. Said that appointment of substitution of counsel is warranted only by showing of good cause. Good cause may exist when a legitimate difference.
I understand that. I don't need you to read that to me. I know what the standard is.
And it stands right here, Paul Stout. Mr. Guramuthi's filed a motion, said there's been a breakdown in the client, destruction of communication and breakdown in the current attorney-client relationship. I filed several motions. There's been a breakdown in attorney-client relationship beyond repair. Beyond repair. If you send me to trial with Mr. Guramuthi, Your Honor, that's automatic grounds for appeal.
Here's where things get intense. The attorney lays out the chaos. Endless grievances, malpractice concerns, and discovery disputes that are overwhelming him. He emphasizes that the client, Mr. G, has made false claims about missing evidence, like discovered materials, even though everything has been provided. Yet, there's one missing piece, the body cam footage, which only arrived this morning. This moment perfectly illustrates the daily grind and the emotional toll of representing a combative client. It's a rare glimpse behind the curtain of legal practice, showing that even seasoned attorneys face impossible dilemmas when cooperation breaks down.
Right here, Mr. Guramuthi's withdrawal is dated December 9th. December 9th, dating where is it? I got it right here, Your Honor. I'll pull it out of this one. The notice for hearing for today, dated December 9th, 2024, for an April 8th, 2025 court date. That's 4 months ago. This paper right here is grounds for an appeal. You know, Mr. Seeger, 150 days. Here's another 4 months. Mr. Guramuthi didn't represent me. That's 9 months out of the 18, Your Honor. My 180-day rule was violated. My right to a speedy trial was violated just because of these issues. Mr. Ziegler in his motions are quoting COVID-19 case laws for violating my 180-day rule and my right to a speedy trial. You read the motions, Your Honor. I've actually got them right here if you want to go through them again. His motions are quoting COVID-19 case laws for violating my 180-day rule and my right to a speedy trial. There's grounds for appeal. Any case is prolonged for more than 18 months. The people's got to answer for it. By the time I go to court in May, it's going to be 19 months. That's automatic grounds for an appeal. The people are going to have to answer why I wasn't in trial before 18 months.
Okay.
You know what I mean? I'm trying to save the court's time, Your Honor.
Now things escalate further with the FBI interview. The lawyer explains that Mr. G initially wanted the interview, but then became angry once it was recorded. The tension here is palpable. Threats, refusals to disclose information, and conflicting agendas are all colliding. This isn't just a legal dispute. It's an emotional battlefield. And notice how the lawyer struggles to balance his duty to advise Mr. G on his rights with the client's unpredictable behavior. Moments like this highlight why courtroom cases often become as much about personalities as they are about the law itself.
Murphy being appointed as your attorney. The fact that you filed grievances against him or other attorneys isn't a reason for the court to appoint new counsel. It's not a reason for the court to allow counsel to withdraw. That's been through case law clearly established that defendants are not allowed to delay cases or shop for new attorneys by filing grievances in the hopes of having that attorney disqualified or somehow being required to withdraw. So the grievances aren't a reason. MIDC has addressed your request for new counsel. Under the law, it's clear that the court is to be minimally involved, if at all, in that process. This is the last step, which is the only reason why it's before me, but it's clear that the legislature has determined that the best process is for the court not to be involved because the court's supposed to be impartial and it shouldn't be involved in issues relating to your counsel. So this is only here as a last resort, but MIDC has followed their policy and procedures and they've denied you from receiving new counsel. So the MIDC, through two different administrators, have determined that there isn't good cause for you to be appointed new counsel. I have concerns, as I articulated before, and listening to you, it just reinforces those concerns that it doesn't matter who's appointed to you as your counsel. I'm convinced that you're undertaking a course of conduct here to create appealable issues on your own, and you've admitted it. You're on the record. You told me that you purposely didn't say anything about paperwork that you received and let counsel go forward in the hopes that that's going to create an appealable issue. So I think you're actively, and I want the record to reflect that I think you're actively trying to do things here as part of the pretrial process in hopes of creating appealable issues so that if you are eventually convicted, you'll have a basis to come back. And I think that's important because to the extent that I would find good cause to appoint you different counsel or to have Mr. Guermity withdraw, I think you continue along the same course of conduct with the new attorney. Not only to delay as long as you could in the hopes of getting to the 180-day issue or whatever you perceive to be as issues that could result in a reversal of your conviction later, including delay, including complaining about your counsel, including doing things in your interactions with your counsel. All of that, I'm convinced, is a deliberate course of conduct on your part aimed at creating appealable issues. And I'm not going to allow you to just continue to do that over and over. I think there is not cause here to appoint new counsel because, again, I think the same issue would simply come up over and over again. We did have hearings on the motions that Mr. Guermity felt had legal merit. I agree that they had legal merit, and I made rulings on those issues, a lot of which involved issues that you're raising here.
The court now weighs in, underscoring the systemic problem. Repeated withdrawals, grievances, and delays threaten the entire timeline. The judge is focused on justice and efficiency. There's a trial scheduled for May, and appointing yet another attorney could push things back months. The commentary here is clear. The system is designed to prevent manipulation. A defendant cannot endlessly cycle through attorneys hoping for favorable outcomes. It's a delicate balancing act, ensuring fair representation while preventing abuse of the process. Courtroom drama is at its peak when personal conflicts clash with procedural imperatives, and this segment demonstrates exactly that.
I was very quiet. I let you say everything that you wanted to say. Now it's my turn. If you're going to keep interrupting me,
Sorry.
I'm going to have you removed from the courtroom and I'm going to continue to make my record. again, I don't think there's good cause because I don't think this is a legitimate disagreement between you and counsel. I don't think I don't think you're raising legitimate points. I think this is, again, strategy on your part to try to delay the trial, to create an appealable issue in and of itself, or to create problems with counsel, to create appealable issues. And I'm convinced that, again, to the extent that I would appoint new counsel, we'd be back here in 3 months with the exact same issues. I think Mr. Gurmurthy filed motions on the things that he felt had arguable legal merit. The court made rulings on those motions. So the court is going to deny your request for appointment of new counsel. In terms of Mr. Gurmurthy, your motion to withdraw, I agree with Mr. Ziegler's sentiments that you're not in an enviable position. It's a difficult position to be in. I agree that you don't have to put up with abuse. Mr. Galt, to the extent that you're going to argue with, verbally abuse your lawyer, you're only hurting your own case. And so I would suggest to you, you've got a trial date coming up in May. I would suggest to you that it's in your own best interest to start cooperating with Mr. Gurmurthy and start working with him instead of working against him. But that's up to you. You're going to make that decision. We're going to go forward with trial in May as scheduled. Mr. Gurmurthy, the court's denying your motion to withdraw for the same reasons that I'm not allowing new appointed counsel. And the only thing I would say, Mr. Gurmurthy, is to the extent that Mr. Galt doesn't want to cooperate with you, to the extent that he engages in abusive verbally conduct with you, arguing with you, he's only doing that at his own risk. And again, I'm sorry that you're in that position, but I think that's where we're at. So, and Mr. Galt falls in your court as to whether you want to work with your attorney. But we're going to proceed with trial as scheduled in May. Mr. Gurmurthy, I just request that you prepare an order that reflects the court's ruling today. Submit that under the 7-day rule.
I was just going to send it to Mr. Ziegler for approval. It was submitted. Normally, we're good with community members. I used to.
That's fine.
Your Honor.
Yep.
Does it matter that this was never, his appointment was never consented by me and never ordered by a judge?
I guess that's something you can bring up on appeal if you're.
Okay. And the fact that Mr. Gurmurthy has admitted that there's attorney-client breakdown beyond repair?
I don't know that he's done that.
He did. It's in his motion.
Here's a key turning point. Mr. G passionately argues that the motions he requested were entirely legitimate, not frivolous. He details body cam requests, motion delays, and even typos in police reports. He's making the case that every detail matters when a life is on the line. This part of the transcript reveals a crucial tension in criminal law. Defendants have a right to assert their concerns, but attorneys must judge which claims are valid or actionable. The back and forth here is loaded with emotion, frustration, and a fight over procedural justice, making it a must-watch moment for anyone fascinated by courtroom strategy.
Your attorney today?
Yes, sir.
Okay.
Your Honor, I want to withdraw my plea.
Okay. What's your basis for that?
Well, Your Honor, will you bear with me for a minute, please? The 14th Amendment of the United States Constitution provides no person shall be deprived of life, liberty, limb, or property without due process of law. Okay. Now, I'm sure, Your Honor, that you're familiar with the great liberality standard. The United States Supreme Court in People versus Benchek, 360 Michigan 430104 NW 2D 191. The Supreme Court in Benchek Supra, page 432, stated, generally, it is considered that there is no absolute right to withdrawal of a plea. But this court's decision suggests that the trial judge's discretion be exercised with great liberality when the motion is made prior to sentence or commencement of trial. I have a motion here with me today, Your Honor. The same great liberality standard is to be applied when the request is to withdraw a plea of guilty or no contender plea. The Benchek and Prodigy are founded on the premise that the right to a jury trial is so important that exercise of that right should not be impeded by belief in the defendant's guilt. Okay. Under Michigan Court Rule 6.310, withdrawal or vacation of plea, B, withdrawal after acceptance but before sentence. Number one, A plea may be withdrawn on defendant's motion or with the defendant's consent only in the interest of justice. In People versus Bonneville, 291, Michigan App 363, 376, 804 NW2D 879, and Bonneville 291, Michigan App at 377 states the following. A motion to withdraw a plea before sentencing should only be granted if the defendant is able to show that withdrawal of the plea is in the interest of justice, meaning the defendant has to articulate a fair and just reason for withdrawing the plea. Fair and just reasons are an actual claim of innocence or a valid defense of the charge. Your Honor, I'm innocent. My valid defense of the charge is I have DNA results from 2 different forensics labs of Jessica's fingernail clippings that say there was multiple contributors to DNA found under her fingernails, but there was no match to my DNA.
This segment intensifies as Mr. G cites his right to a speedy trial and potential grounds for appeal. He points out that by the time trial rolls around, the case will exceed 18 months, automatically creating legal complications. The discussion about COVID-era case law, delays, and procedural missteps shows how high the stakes are, not just for the defendant, but for the entire court system. It's a textbook example of how technicalities can shape the fate of a case. Here, we see a perfect storm. Legal rights, delays, and client dissatisfaction all colliding, creating an electric courtroom atmosphere.
I asked for a continuance to hire my own attorney, Your Honor, and you denied me a continuance.
Right. So we were ready to go to a trial. We had jurors here ready to hear your evidence that you have here with you today.
Your Honor,
You waived your right to that and you entered a plea on that day. So why should I now allow you to withdraw that plea?
well, Your Honor, for several reasons, okay? I filed 4 motions for substitutes of attorney that were denied. Mr. Guramuthi filed a motion and terminated his attorney-client
I
relationship
know all of that.
2 months before trial.
That's not a reason for me to allow you to withdraw your plea. You knew all of that at the time you entered your plea.
A legitimate claim of innocence and a legitimate defense to the crime is reasons to allow me to withdraw my plea.
It's also reasons for you to go to the trial that we had ready and set with jurors here ready to go that morning.
With an attorney that terminated his relationship with me and we didn't prepare for trial, Your Honor.
You had plenty of opportunity. I'm not going to argue with you. You waived your right to that jury trial and your right to present all of that evidence that morning on the record. Right? I explained all your rights that morning, didn't I?
Can I finish reading this?
Didn't I explain all your rights that morning?
Yes.
Yeah. And you said you understood them?
I've
Right.
never signed an advice of rights form in relation to.
You stated on the record that you understood your rights, did you not?
Your Honor, I never signed an advice of rights.
That's
form
not
in
my
relation
question.
to this case.
That's not my question. My question is, you stated for the record that you understood all your rights, didn't you?
Your Honor, I have with me
Okay.
today medical reports that shows that Jessica died from internal bleeding due to cirrhosis of the liver. I have the medical reports right here with me
Okay.
for the family.
You,
I can
you
show
had,
the
you
family
had
the
your
medical
opportunity to present all of that to a jury. And you declined that opportunity, you accepted a plea. Under the court rule that you cited, which is correct, NCR 6.310, you need to show that there was some type of error in the plea taking process. The plea taking process. That means what we did on the record that morning in taking the plea. So I need you to tell me what you think the error was in the plea taking process.
Well, Your Honor, I believe the error was the fact that you participated personally in the plea negotiations with my attorney and the prosecutor in the judge's chambers,
Okay. How was
according
that?
to
How was
People
that?
versus Green, People versus Cobb, and People versus Killebrew. It says, we hold that sentencing concerns are appropriate subjects for plea bargaining. However, we hold that judges' roles in plea negotiations, and sentence bargaining included, is limited to consideration of the bargain between the defendant and the prosecutor. The judge may not become involved in the negotiations. Due to the nature of unequal bargaining positions of the judge and the defendant, any involvement in the negotiations transforms discussions into perceived coercion.
Yeah, I was not involved in the plea discussions.
Mr. Guramosi told me that you,
I asked the attorneys whether there was a plea agreement, and they indicated to me that you wished to enter into a plea agreement, which you confirmed on the record.
Mr. Grimo,
Finally, the judge lays down the law on court-appointed counsel. Mr. G is reminded that he can hire his own lawyer, but the court cannot simply replace counsel due to grievances or personal disputes. Case law is crystal clear. Defendants cannot delay proceedings to shop for new attorneys. The judge emphasizes impartiality and adherence to MIDC procedures. This VO highlights the fine line courts walk, ensuring fair representation while keeping the trial on track. For viewers, it's a masterclass in legal boundaries, demonstrating how frustration and personal conflict meet systemic rules in high-stakes cases.
other than the fact, Your Honor, that I have a legitimate claim of innocence
Okay,
and I am innocent and I have a valid defense to the charge.
okay.
I have the
Right.
DNA results. I
All right.
have the
Thank you.
Verizon
You've
wireless
stated your
report.
basis. I appreciate that. Mr. Grimmer, is there any other legal argument you'd like to make on Mr. Galt's behalf?
Regarding the withdrawal of plea, no, Judge. I've done my research. I've indicated to Mr. Galt, under the court rule, there was no legal error in taking of the plea. I've indicated to Mr. Galt, the court was not involved in plea negotiations. Mr. Ziegler, the morning of trial, and the jurors were here, renewed a plea offer that Mr. Galt then accepted. That's the process of what occurred. And then we did ask the court if the court would allow Mr. Galt to enter a plea and release the jurors if he entered a plea. In my experience, once the jurors are here, this court has not allowed that to happen, and essentially, at all plea cutoffs, essentially has treated that as a plea cutoff. And that certainly was not the case in this matter, because the court did allow, based on the renewal of the plea offer from Mr. Ziegler's office.
Correct. Okay, that's correct. Mr. Ziegler, any response to the people on the defendant's motion?
Just two things, Your Honor. As to what Mr. Gurmurthy just said, I would confirm for the record that the plea offer has been the same pretty much since the inception of this case. The court was not involved in any negotiation or amendments to the plea offer. The offer in this case has been and has always been for over.
To wrap things up, this courtroom saga demonstrates the high tension of legal battles when attorney-client relationships collapse. We've seen frustrations, threats, procedural disputes, and rights argued passionately from both sides. The judge ultimately reinforces the rules, protecting trial integrity while acknowledging the breakdown. The key takeaway: the legal system has safeguards, but human emotion and personalities inevitably shape courtroom drama. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns.